And hello and welcome everyone to Phoenixville Public Library. I'm Mark Pinto, the Adult Services Director, and we are pleased to present tonight this program on probate and estate planning presentation from Jim Ruggiero of Ruggiero Law Offices. He is the owner of Ruggiero Law Offices, with offices in Paoli and Center Valley, PA, where he practices in estate planning, estate administration, elder law, business law, and real estate. He's achieved board certification as an estate planning law specialist, and he has attained designation as an accredited estate planner. He's been recognized in Mainline Today and Philadelphia Magazine as a top attorney in trusts and estates and elder law, and a 5-star wealth manager for numerous years. Before Jim starts his presentation, we ask that you please hold all questions to the end, those of you in the room and those of you on Zoom. We are recording the presentation, but we'll stop the recording before giving you a chance to unmute yourself or type in the chat to answer your question or ask your question at the end of the presentation. So with all of that now, we welcome Jim. Jim, take it away.
Mark, thank you. And thank you to the Phoenixville Library for having us back again to speak in person. We were here virtually in the pandemic a few times, but it's nice to be out in the town of Phoenixville tonight. And we're going to keep this to be about 45 minutes of too much of Jim talk, but then we'll be happy to answer questions for about the last 15 minutes. So please get your questions ready, and we're happy to answer all of them when we're done. But we do want to talk about our topic tonight, probate. Is this what your loved ones deserve? So probate, it's a Latin word. It means to register. So in Pennsylvania and in the United States, when you have to probate a will, you physically have to go to the Register of Wills office and register it. That's the probate process. That's how probate begins. So we're going to expose the process, talk about it, talk about the pros and cons throughout this evening. And fundamentally, what we like to focus on is planning. And so probate can be part of a plan. Avoiding probate can be part of a plan. It all ties into what is your particular individual situation. Everybody's different. So we want to make sure that we touch on what a single person should worry about, what a married person, what a person with children should worry about, grandchildren, people who are retired. I mean, there's a lot of different things that one should look at. Unfortunately, there's a 100% probability we're all going to die. We know this. It's terrible math, but knowing that, to be forewarned is forearmed. And so knowing that probate can be avoided is something that we want to tell the audience as well. It doesn't have to occur. It's not a necessary evil, and it's also not a dirty word. It's a process. So that's us. We've already heard this nice introduction from Mark, so we'll move past that. And when we talk about planning to avoid probate, we do a lot of wills and trusts and special needs trusts and retirement trusts and life insurance trusts to put assets away for your family and your loved ones and to avoid taxes and avoid probate. So probate, this administrative process, as you'll find out, can take a while. It can take 12 to 18 months in the Commonwealth of Pennsylvania. So we do a lot of estate administration, but we're not wanting to be in the business of estate administration. We'd rather help families have their trusts administered because it's more efficient and less expensive, in our opinion. So in looking at your life, you've worked hard. So planning is to ensure that you're protecting your life savings, protecting yourself and your loved ones. And people ask me, Jim, why do we do an estate plan? Well, it's simple. You do it because you love your family. That's the reason to do it. If you don't love your family, don't bother. It doesn't matter. Let it be someone else's problem. But if you love your spouse, you love your children, we take the time to put a plan in place. I love to say, whether you're 18 or 108 years old, you need an estate plan. Whether you've got $10,000 or $5 million, you need an estate plan. And why do I call it a plan? Because it is a plan. Because we have to plan for what happens in your life today and what happens tomorrow. And I like to say that one of these tomorrows we're all going to have where that's that 100% probability we're all going to die. So one of these tomorrows, I won't be here. You won't be here. So we know that. So we can plan for that. All right. It's not an ideal outcome. We can't plan around it. Not yet. We're not able to get downloaded into the machine. I'm not really interested in that. But what is probate? It's a legal process. We make sure that if you've written a last will and testament, and you can write one on the back of a cigar carton, because a cigar carton has been probated in the Commonwealth of Pennsylvania as a will, it has to be valid. What does it mean? Well, it's got to be executed by you. It's a writing. It can be what we call a holographic will. You can hand write it out.
Jim, I'm sorry, you're kind of blocking the screen for the people in the room here.
I'm sorry. I've been told I make a better, wall than a window, so I understand.
Sorry about
my
that.
apologies.
Okay.
Anyway, so this process appoints a trusted individual to act on your behalf after you die, because you put in your last will and testament who's going to be my personal representative, or also executor. All right, so if you have a will, you name an executor or an executrix. You can have more than one person serve as your personal representative after you're gone. And this is, again, an advocate, someone who is willing to act on your behalf when you're no longer here. And their job is to wind up your affairs, carry out your wishes, transfer your property to your loved ones, chosen beneficiaries, charities, all these things that one can possibly plan for. We have stuff. Where does the stuff go? My wife's in the back, and she's lovely, but she doesn't want my 10,000 comic book collection when I'm gone. She wants that gone. So it's some things we need to take care of. We're alive, but it's property. It's things that need to go somewhere when we're gone. We're talking with clients today. Her brother died 4 years ago. We've got boxes here. We've got boxes there, but we haven't finished taking care of the stuff. And he died without a will, so that made that a little bit harder to take care of determining what was supposed to happen. So probate is there to help. It really is. And in Pennsylvania, it started at the county seat of the county that you died. So when do your loved ones have to go through probate? Well, it's if you decide you want to make sure that it happens that way, and again, that's a choice. We like to counsel families to avoid the process, just so I'm clear on this, but if you have accounts that are owned solely in your name, if they're payable to your estate at death because you failed to update a beneficiary designation, or we say missing a beneficiary designation. We just had a life insurance check come into the office to our client's mother's estate. Why? Because her husband who predeceased her was the beneficiary, and then it was her parents. So her parents predeceased her as well. So the life insurance check ended up in her probate estate. And that's not an ideal outcome for life insurance, because life insurance is not subject to Pennsylvania inheritance tax. So it doesn't need to run through the estate. That's why life insurance is an important planning tool for families. So it'll just go out to your beneficiaries in the terms that you have laid out. It can go outright, it can go into a trust, but if it runs through your estate, it's subject to the claims of your creditors. So this is why having your beneficiary designations updated regularly is really important. So we talk about keeping a plan updated. It's really important. We got a phone call today from a client who we had not talked to since 2007. Now, by the way, we had written them saying, come back in and update your plan, and we sent them a letter last year saying, if we don't hear from you, hey, it's time to move that file into the shredder because it's been so long. They called. And oh, by the way, they moved and they didn't tell us. And it happens. But they were ready to update the plan because, hey, every 14 years, why not, right? But things had changed in their family. So when you go through probate, if you have an asset just in your own name, not in husband and wife. If you're married and you own a house, most times you'll have both spouses' names on the deed. So that's an ownership called tenants by the entirety. So when the first spouse dies, that house goes to the survivor by operation of law. If you have a bank account with your brother and your brother dies, that bank account goes to you by operation of law because it's a joint account. If it was just in his name, it has to go through probate. So why would you want to avoid probate? Well, probate is a public process. When you register your will, it becomes a public record, all right? So I don't know about you, but I don't think the world needs to know your business. So when we use a living trust as our client's fundamental legacy planning tool, that does not get probated. That has its own terms, and it doesn't have to be put on file at the Register of Wills, so it's not a record for the world to see. You see, wills are the rich and famous all the time written about. Why? Because they've been probated, so they become a public record. And, you know, I told you it takes a long time. It does. It's about 12 to 18 months for probate to occur and be completed in the Commonwealth of Pennsylvania. It can also be expensive because by failing to plan, there can be a lot of work that has to be done after you die to value your property, to get appraisals of a business, to get appraisals of real property, to get appraisals of art, file tax returns, file an inheritance tax return that we know will get audited. So all these costs can add up. You have executors' fees, you have legal fees to go through the probate process, which, because things weren't done in advance, you've got to go do them after your death. And so that means more work that could be avoided if you took care of things during your lifetime. So we're in favor of lifetime planning. So why would you want to go through probate? Well, you can have a court-ordered distribution of assets out. And if you die without a will, that's called an intestacy. You can have your estate be administered, and a judge can order the distribution of your assets out to your rightful heirs. Lots of times people will fight over people's assets, and we want to avoid pre-death will contests. A will validates what your goals are. You might have a child who has problems, and so you want to put an asset in trust for them. So you probate that will so that asset goes into trust for them after you're gone, because you don't want to do it with your lifetime. You designate someone again to take care of your final debts, your final taxes. It can be an easy way to handle smaller matters. I'm not generally a huge fan of having to probate small estates because of the work versus the cost. So this is why we like to, again, avoid probate on smaller estates. Well, and yes, a judge can make sure everyone behaves. Well, that's not true. We know a judge can't make sure everyone behaves, but they can keep them in line to follow the law, and if they break the rules, the judge can enforce the law and make sure that things are handled properly. So we don't want to be there when the fight breaks out. We want to stop the fight from breaking out. That's the benefit of planning. When you don't have a plan, that's when we see the fight break out. When plans aren't updated, that's when the fight breaks out. When children who you think are going to be able to take care of themselves, all of a sudden you realize my child's 50 years old and they're still relying on me to help pay the rent, that's a problem. And you've got other highly functional children who are able to take care of themselves. You want to make sure perhaps you should set up something through your probate will to take care of them. But you can also do that in other fashions. So how can probate be avoided? Well, you have to ask the question, do you want to go through probate or not? My general answer to that question is no. No one wants to have an estate go through probate if it's unnecessary. If it can be avoided, we want to avoid it. That's why we do the planning while you're alive, to set things up. So again, make sure that you die without having any accounts or property in your individual name. You have your spouse on the account. You have a child as a co-owner on the account. Then those accounts won't get frozen upon your death, because that's what happens. If you die and it's just in your name, the ability to access the bank account is ended. An agent under a general durable power of attorney loses the ability to act as your agent once you die. And until your personal representative gets appointed, no one has the authority to act over your individual property that is now frozen as a result of your death until the probate process gets going, unless you have things that will transfer on death, you have beneficiary designations, you things that pay on your death as part of a plan. So these are some methods to avoid probate. It's not the only methodology, but it's part of a plan. You may have a trust that would avoid probate, but you're still going to have a checking account at the local bank that you pay your bills out of regularly. So you don't want to have that account be frozen upon your passing. So we always advise that if you have the ability, you have a child, go on the account after a spouse dies. It's not that they're going to be the co-owner. We call this a convenience account, but they will be on this account for you for the convenience of your family after you're gone, so that they can write a check to pay for the flowers for the funeral. They can pay for the luncheon. They can pay the funeral director. Lots of times people get concerned, how am I going to pay the water bill? How am I going to pay the electric bill after mom or dad die, because the account's frozen? And you have to complete the probate process in order to get access to the money. Or you can have a joint account set up and you can still pay the bills. So, important probate avoidance tools from a planning perspective from us as lawyers. Well, a revocable living trust. It's a will substitute. It's better than a will. Why is it better than a will? Because it takes care of you during your lifetime, and it takes care of you when you die. The purpose of a trust that's a revocable living trust is to create an umbrella. And underneath this umbrella is your property. You put it underneath the umbrella of your revocable living trust so that it doesn't get lost in probate. So if you become incapacitated, you've got a successor trustee or a co-trustee who can manage these assets. You don't have to worry about having a power of attorney that you did 10 years ago not being on file with a bank, and all of a sudden the bank says, we need a more recent one. And so they give pushback, and it creates problems. So one of the best estate plans to avoid probate, spend it all during your lifetime. Give it away. Have your last check bounce to the IRS. That's a great plan. Die broke. Spend your retirement money in your retirement, folks. Don't worry about the next generation down. They've got to save for their retirement just like we have to save for our retirement. So, yes, make outright lifetime gifts as long as you're not going to impoverish yourself, alter your lifestyle. You don't give away the house and think that you've done a good thing by putting your child's name on the deed for $1. I had this conversation this week where dad put his 4 children's name on the deed on the Avalon house for $1. Everyone thought it was a wonderful idea until I explained to one of the children that she now has a $300,000 tax bill, okay, if she sells her quarter of the house, because dad gave her the house with the 3 siblings for $1. And the children got dad's cost basis in a house that was bought for $300,000, and now is, crazy world, $6 million. But you go sell your $1.5 million share, you've got to pay capital gains taxes of 20% plus on that $1.5 million. If dad had put the house into a revocable living trust in New Jersey, his children would have gotten a step up in the cost basis upon his passing. They would not owe capital gains taxes, and there's no inheritance tax in New Jersey to Class A beneficiaries, which are your children. So they each would have inherited $1.5 million tax-free. Pennsylvania, you'd have to pay an inheritance tax of 4.5%. But because they made a lifetime gift of real estate versus cash, it was a significant negative impact. So we have accounts where we can put beneficiary designations on file. Life insurance. 401ks, 403bs, IRAs, POD on bonds, transfer on death designations. These are things that help avoid probate. But you can't just put everything in, for example, joint names. We've had the three little old lady sisters, and I'm an old man now, so I can say this, where they put everyone's name on the accounts. That was their plan, to avoid probate. Well, one of the sisters died, and all of a sudden two sisters had to pay inheritance taxes on their own money because it was their money that they added their sister's name on the account to avoid probate. They had to pay 12% inheritance tax on the third that they got back, which was already theirs from their sister. So again, planning is important as a part of this. So you can do a deed where you retain what's called a life estate. So I want to stay in my house for the rest of my life, but I'm going to retain what's called a life estate so they don't pass down to my children. So that keeps the house out of probate. Again, I'm going to keep going back to a revocable living trust, because I can put your house inside a revocable living trust and keep it outside of probate. And it'll still pass down to your children after you're gone. They can avoid the capital gains tax issues. And that works really well for my clients who have property in multiple states. You've got a house in Maryland and a house in Pennsylvania. People have a Florida condo. All these go inside your revocable living trust. Why do we want to do that? Because we don't want to have probate in two states. If you own real estate in Florida and you own real estate in Pennsylvania and you die with that real estate owned by you individually, your executor has to probate your will in both states, has to go through the process in both states. If it's inside a revocable living trust, no probate. So it's a really good probate avoidance tool because it's going to save money for your family. Part of the reason why we push the use of a revocable living trust for our client families is because it's so much less expensive to administer a trust than it is to probate an estate. Now, not a lot of law firms want to hear Jim say this, by the way, but we're different because they love making money on estate administration and probate. It's a big part of their practice because they've been writing wills for 50 years. And so when their client families die, they do the probate. And there's more expense associated with probate. We don't want to be in the probate business. We want to be in the planning business. So our firm promotes revocable living trust so client families don't have to go through the probate process, don't have to go through the payment of an executor's fee, the payment of an administrator's fee, where it can be done much more efficiently through the use of a revocable living trust. It's not a new tool, by the way, but it's a tool that is very popular in California and very popular in Florida and has been for decades. Why? Because probate is a real pain in California. You can't sell a house inside an estate without court approval. You have to advertise it, and people can show up at a sale in the court and say, I bid $10,000 more, and they can upset a sale. I watched a piece of property that was under agreement to sale get overturned 3 times before it finally got sold because of the California process. Now, it was inside a trust. The trustee could sell it, would not have a court requirement that they approve the process. And in Florida, if you're not a Florida resident, you can't be the executor of a Florida estate because the game is rigged. Why? Because it's a hometown deal. Takes care of the Florida bar. All right, so if there's Florida lawyers out there, they're going to be mad at me when I say this. But if it's a trust, you can be the trustee. It doesn't matter where the trust assets are. But it's an estate. If you don't live in Florida, you might live in Florida, but your children might live in Pennsylvania. They can't be the executors for handling your Florida probate assets. So, again, I come back to, what do you want to do? Well, you want to enjoy your property while you're alive. When you're gone, you want to make sure it goes to your loved ones. And this is where we do the planning. Inside that Rev Trust is the same terms that you would have in your last will and testament. So when you think about, well, I don't need a trust. Well, inside wills we write trusts. Inside our trust we write trusts. That's just part of the planning. But another important way probate is avoided is joint tenancy with rights of survivorship. What does that mean? Co-owners on a deed. There's 2 ways that you see ownership on a deed between a brother and a sister. It can say tenants in common, or it can say joint tenants with rights of survivorship. So what does that mean? We all hear about the game of Survivor. It's the last sibling standing that owns the house that they got from mom and dad, if it's joint tenants with rights of survivorship. Now, we don't recommend that for a beach house because that's not good future planning on how to deal with the family vacation home. But husband and wife. My wife and I own our home as Jim and Beth, tenants by the entireties. That's a joint tenancy, but because we're married, it's a specific type of tenancy that is one that can't be severed. Tenancy by the entireties is an interlocking ownership. When you're married, you own 100% of the asset. If you're joint tenants with rights of survivorship, not spouses but siblings, you can divide that ownership interest if there's a fight, if there's a lawsuit. So important to understand that. But tenants in common means when I die, it's going in my estate. When you die, it's going to your estate. So you're automatically going to create a probate asset if you own something as a tenant in common. Now, there can oftentimes be good planning reasons to make sure the ownership interest is tenants in common. And the world we live in today, we've got unmarried couples buying real estate together, but they have children from prior relationships. They've been together, but they're not getting married. But they spend all of their time contributing to the house, but their children won't get half of the equity built up in the house if it's a joint tenancy with rights of survivorship. And that's not fair to the children from the prior relationship necessarily. I mean, these are things that have to be discussed. You have to deal with these issues. We find couples that are breaking up, and all of a sudden they find out that they have a deed that says joint tenants with rights of survivorship. Well, that's not good because they can't have a will that directs their half to their children because the property doesn't pass through probate. It passes by operation of law. So we have to complete a lawsuit, what's called a partition action, where you have to sue your former life partner to sell the house, to divide up the house, because you own the property with them as a joint tenant with rights of survivorship. But you can't leave it to your children because the deed was done wrong by the title company. That you didn't think about it, that no one asked you the question on the way in. And when you're on the way in, you're like, happy, we're buying a house together. This is great, we're so excited. This is going to be terrific. And it is, until it isn't. So 5 years down the line, the relationship ends and you find out, wow, if I die, my kids aren't going to get the $300,000 of equity that I have in this real estate that I put $100,000 of my down payment money down on it. I paid the mortgage. I fixed it up. The real estate market appreciated. So this is where you wouldn't want to avoid probate with joint ownership. You need to be responsible in how you do these things. So I'm saying it's all about the planning. So when we talk about planning, it's multifaceted. And again, I talked about outright lifetime gifts. They're great if you're the beneficiary, and they're great if you're the grandparent giving the money away because then you get to hear the thank you. I'm a huge fan of lifetime gifts so that the people who receive the gifts will say thank you to you, and then you can see how they act when they get the gift. I'm not saying give a gift that makes someone a trust fund baby where they don't have to work for the rest of their lives. I mean, nice work if you can get it, but give someone a gift, see how they're responsive. Okay, but when you give the gift, understand it's a gift, it doesn't get to come back. So that's why we don't advocate giving away all of your assets. But again, what is the pro? It's outside of your estate. What's the con? Well, you don't own it. So if you need it, it's gone. So that is something that you have to understand. And if you just give an outright gift to a child, well, what if they're a spendthrift? Their creditors can get it. So I talk a lot about trust because I'm a huge fan of creating trust as guardrails, as protection for your family, as creating safe deposit boxes where you can make a deposit of a gift of love. That can be money, it can be stock, it can be real estate, but it's for the benefit of your children and you leave it in trust not because you don't trust your children, but you don't trust your children's spouse. That, lots of people get divorced. We know that, approximately half of the marriages in the United States end in divorce. But only 1/3 of the people who get married get divorced. They get divorced more than once. So 2/3 of the people that get married stay married. But if you get divorced, you've got to divide your assets. If you've given your child $100,000 as a gift, and they put it inside a joint bank account, and a divorce occurs, it's a marital asset. It can be divvied up in equitable distribution in a divorce. Lots of times families say, I want to buy my child a house, or I want to give them a down payment on a house. So they'll give a substantial cash gift to buy a house. And then a divorce occurs, and that cash gift gets split with the spouse that's going out the door. So you have to think about these things. We want to make sure that gifting is done the right way. So when this last line, it says talk about your available lifetime exclusion amount, it's talking about the federal estate tax. We're not talking really tonight, folks, about the federal estate tax. Why? It affects a very small portion of the United States. The current exemption per individual from the federal estate tax is $13.2 million. I don't have a federal estate tax problem. A married couple can exempt $26.4 million from the federal estate tax. And that's until January 1, 2026. My clients don't have that problem. Okay, so we're not worried about that. At the end of the day, middle class folks don't have to worry about the federal estate tax. All right, the Bezos and the Buffetts of the world do, but we're not here tonight on Zoom or here in person. Okay? Beneficiary designations are extremely important because if you don't keep up with them, the right person might not inherit the asset. Now again, it does help avoid probate. But when we talk about beneficiary designations, it's important to understand that, yes, most commonly used with life insurance or retirement accounts. Your retirement account is yours during your lifetime. Your IRA, your 401k, your 403b. You take it out. After 73, you have to take required minimum distributions. You spend it in your retirement. It's yours. You can't change the ownership of it during your lifetime because it's yours. And it's in trust because you haven't paid taxes on it. So when you take the money out of traditional retirement accounts, you have to pay income tax. Once the money comes out, you can give it away. But if you don't have the right beneficiary designation, that's a problem. Why? Because we have something called the Secure Act 1.0 and the Secure Act 2.0. We presented in the pandemic webinar here for Phoenixville about the Secure Act. It changed the rules. The rules have changed and not everyone's aware of them, and it started in 2020 with regards to retirement accounts. If you inherit a retirement account from a parent, you now only have 10 years to take the asset out of the retirement account. So you've got to pay all of the income taxes within 10 years. Now that's if you name an individual as the beneficiary. If you don't have a beneficiary done the right way, and it's just an estate because you didn't update the beneficiary, you have to take it in 5 years. You don't get to hold it for 10. It's cut in half because you didn't keep up with your beneficiary designations. And again, there's good reasons to plan where a retirement asset goes. If you have a disabled grandchild, it makes a lot of sense to think about leaving them a retirement asset because they can have it stretched out over their lifetime instead of having it come out by the end of a 10-year period. So again, a lot of different moving parts. So when a beneficiary gets an account outright, there's no protection for creditors. One of the biggest things that we're doing for our client families now is making sure that their retirement accounts, oftentimes their biggest assets, don't go out to their children individually, that they go into a standalone retirement trust to give them protection from creditors, protection in the event of divorce. So there's probate assets, there's non-probate assets. You have to look at each asset and look where would you want it to go. What are the tax ramifications of leaving it in trust or leaving it out of trust? There's a process that occurs when planning gets started. But it's not just one and done. Every 3 to 5 years, you've got to check it. You've got to go.
Okay, but I'm coming.
Please mute yourself on Zoom. Thank you.
Everybody needs to get an annual doctor's checkup. So I just saw that they were trying to say you don't need to go to the doctor every year in the news, and then the fob was, yes, you should go check in with your doctor every year. Well, we're in charge with your estate planning help, so you should go every couple years. You don't need to go every year, but tax laws change, life events occur. You need to keep up with it. Candidly, the gentleman who hadn't reached out in 14 years, that's a long time. Nothing had really substantially changed in their individual lives. He and his wife are doing well, retired in Florida, but now they have concerns about their adult children not being able to manage an inheritance. So things did change that, that is leaving them awake at night, worrying about a child getting an inheritance that they're going to blow. We want to have our children do well. I always say we want to give them fishing rods, teach them how to fish, right? Because when you give someone, a barrel of fish that smells after 3 days, it goes bad, you have to throw it out. But if you're going to leave money to children that are going to need help, good planning says leave it in trust. So you hear a POD. Oftentimes you see that with savings bonds. How many people have savings bonds that they were given by a grandparent or a parent, all right? And you forget about them, but they're still there, but they pay on death. It's the grandparent's name and the grandchild's name. So all of a sudden that goes to the grandchild. When they die, all of a sudden they have to figure out, oh, I cashed in the bond, and they get an income tax bill. All that interest adds up. But again, it can be used with financial guidance. It's simple. And again, you can change who it pays to at any time. Saw this happen where the beneficiary was a teenager, and then they turned 18. So they cashed in all the bonds. They weren't ready to take control over that much money, and so they blew it. So that's a problem, because it can go out to creditors. And again, if they're not ready to take control over a significant sum of money, pay on death designation can defeat the best goals in the world. Transfer on death, similar. Lots of financial institutions will encourage you to create transfer on death designations on your investment accounts. So your retirement accounts have beneficiary designations. Your non-retirement accounts, the institutions will encourage you to set up transfer on death designations. Why? They get 3 new accounts when you die, because the account gets split 3 ways, set up at that institution, and each of your children now has an account at ABC Investment Company, whether they want to work with the folks at ABC Investment Company or not. And they're not necessarily making an independent choice, and all of a sudden it's there, so they might just leave it there. So inaction is part of life. So body in motion stays in motion, body at rest stays at rest. As you can tell, I'm part Italian. My hands keep moving throughout this process because I just don't want to stand here like this. I don't really know what to do. But if you're presented with an account already set up and you don't have to do anything, you're very likely to just leave it there. You might not find out, are my mom and dad's investments what I should be invested in now? Are we going to stay the course, or are we going to analyze my horizon is different than mom and dad's horizon? Mom was into bonds. I need to be in stocks because I need to work for 20 years and I need to have the money grow for 20 years. Stocks for the long run. Again, this is where I'm not giving financial advice, just talking about choices. And lots of times you want to not have too many choices. You go through the drive-thru, there's 19 choices. You're trying to figure out which one is the one you're going to take home. But don't go because it's too expensive today. Did see this in the news. You've heard about surge pricing. They'll charge you more money at busy times. 2 days ago, Wendy's announced that they were going to charge more for their hamburgers during lunch because more people were in line in the drive-thru. So you're going to pay $1 more for your burger. That probably got walked back today because of the outrage. But with a transfer on death, you think it's not a problem. But it doesn't take care of taxes. It doesn't take care of planning. Again, an outright transfer on death says it's exposed to creditors. versus it's inside your rev trust, and then it transfers upon your death to asset protection trust for your children. I'm a huge fan of safe deposit boxes. Not physical ones, because then you have to go inventory them when you're deceased. Your loved one has to go to the bank, and lots of times there's a deed that doesn't matter. There's a title policy. There's things there that are not very valuable, but you've spent money keeping them in a bank where you really don't need to keep them there any longer. So don't keep sheriff certificates at home. Put them on file with your broker. So, thinking about things holistically, we want to avoid probate, but we want to do it in an intelligent fashion. We also might want to have certain things go through probate depending on the individual situation. But the benefits of avoiding probate are many, because you get to keep more money in the family. And that's important. We don't want to have it go out unnecessarily to lawyers, accountants, the Commonwealth of Pennsylvania. I mean, this is part of good tax planning. We love to help our clients with their tax planning, income taxes, inheritance taxes, transfer taxes. So, in thinking about all this, you have to understand, if you give it away, there might be consequences that you don't realize from a tax perspective. That, do you really want to find out? All of a sudden, you've just been told you've got a $300,000 tax bill because you got a house for $1, whereas if you inherited it when your dad died last year, it would save you $300,000. Smith, you'd rather hold on to the $300,000. It's a no-brainer. Okay, so life estate deed. You can say, I'm going to live in the house during the rest of my life. All right? And then it'll go to your children. I don't love it, because if you go into the nursing home, that house then is at risk. We can create a Medicaid Asset Protection Trust and put your real estate inside what's called a Medicaid Asset Protection Trust. At the end of 5 years, the real estate is exempt from being counted as an available resource to pay for your skilled nursing care. So again, outside of the scope of what is probate, but just using a deed, again, we got creditor problems. You're at your end and at your children's end. So you have to look at why you do these things. Joint tenancy with rights to survivorship. Important. Important on real estate. Important on small bank accounts. Understand how it works with you as having a co-owner on it. Again, you avoid probate. But again, you put a child on a bank account, that child can access that bank account. We see financial abuse occur far too frequently. Elder abuse becomes an issue. So we worry about these things. So again, we like to have an umbrella of a trust in place to help. Tenancy by the entirety, again, that's between you and a spouse. Joint ownership. It's a great way to own property for married couples. Tenants by the entirety. It protects against creditors of just one spouse. Ownership transfer is automatic. We always make sure there's no probate when the first spouse dies. We also work to make sure there's no probate when the second spouse dies. Again, creditors can become an issue upon the death of the first spouse, because you don't own things as tenants by the entireties. That's why you talk about planning. So this revocable living trust is the centerpiece of what families should do in Pennsylvania and other states to have this umbrella created for your property so that it's not subject to probate. It's taking care of, you're the trustee while you're alive. Your spouse is trustee with you. One spouse dies, the surviving spouse is the sole trustee. Spouse becomes incapacitated, you can have an adult child become the successor trustee, or children as co-trustees. So there's access to all of the funds while you have capacity. Access to the funds after your death. Now again, is it more to do an estate plan with a revocable living trust? Yes, because you get more. Because there's more that benefits your family when you do it that way versus just writing a will on my death to my 3 children. All right? But when we talk about a revocable living trust, that is not doing any tax planning. It's doing probate avoidance, because it's a revocable trust, because it's you. Your tax ID number is your Social Security number. And so I realize that we've we're coming to the end. I'm a little bit more than 45 minutes, so I'm going to wrap this up. So how does a rev trust work? You are the grantor. I write it. I transfer accounts and property to the trust called the Revocable Living Trust. We continue as the trustee in my lifetime. It's my trust to manage, invest, and spend the money inside the trust. It's a rev trust. Again, we want the last check to bounce, right? Because we've lived a good life. We're not worried about it. We've taken care of our kids. You've paid for college. Their retirement's on them. But if you become incapacitated, you've got a successor trustee who can take care of continuing to manage the assets and pay your bills and take care of you. And again, during your life, you're the one who receives the benefits of this trust, nobody else. And again, why do we have a successor trustee if you can't take care of yourself? This is why. Sorry, my timer went off. And it steps in when you can't take care of yourself. So it's all good. But your beneficiaries, your children, get your money and your property distributed according to the terms that you laid out during your lifetime. And because it's revocable, you can change it throughout your entire life. It's not irrevocable. Big difference between a revocable trust and an irrevocable trust, because when you create an irrevocable trust, you can't change the terms. But you can create a new irrevocable trust if the old one doesn't work, and change ownership and change beneficiaries. So there is a way around dealing with the change in life. If an irrevocable trust no longer works, you can take care of it while you're alive. So what's right for your family? That's for you to decide. We encourage you to consult with us. This is our team at Ruggiero Law. We're proud to be in year 34 of doing planning for families. I'm proud to say my wife, my partner in marriage for 28 years, been in business 34, is here and works in the business, and we've got combined experience of everyone in this picture of over a couple hundred years, folks, between the attorneys and the paralegals. I'm one of the younger guys in that picture, believe it or not, okay? I'm actually the second youngest person in that picture, believe it or not. Experience, it's important. You want a young doctor who has all the latest and greatest info about what's going on in the world. But in this practice, we keep up with the tax laws, planning. A lot of this is common sense. A lot of this is practical. You don't always know what questions you should be asking. We always want to ask you, what questions didn't we ask you at the end of a conversation? Because we want to make sure that we're expanding your knowledge base and addressing your concerns. Oftentimes, something that might be top of mind isn't what one would think you would be talking to your lawyer about, but it does matter. Where are you going to live? Are you going to stay in your house? There are different things that come along in planning that's not just about money. It's not all about money. It's about your legacy. It's about taking care of grandchildren. Should I set up a 529 plan? What's right? Probate, in certain instances, can be helpful. Avoiding probate, for most families, is a good plan. But it has to be in conjunction with, what are your goals? Oftentimes we ask someone, what are you going to do when you retire? What is your retirement plan? You have to retire with purpose. What are you going to save for in your lifetime? I mean, this is all part of planning. It's not just, who do you want to be your executor? Who do you want to be your trustee? We know you're leaving everything to your spouse, then to your children, for the most part. That's part of planning. We put it in writing, get the documents in place, we keep them updated. But what's right for you, that's for you to decide. So I hope that this has been informative and helpful tonight. And now we're going to move on to the questions.